After studying this module, you shall be able to know about Insanity and Mental Health Act 1987, about false and true insanity, about procedures for admission and discharge of mentally ill from psychiatric hospital, about various criminal and civil laws associated with mentally ill. Insanity, which means lunacy or mental unsoundness or mental derangement or mental disorder, is defined as a disease of mind or of the personality in which there is derangement or impairment of mental or emotional process. The Indian Lunacy Act 1912 defined lunatic as an idiot or a person of unsound mind. However, the Mental Health Act 1987 has replaced the Indian Lunacy Act 1912. The Mental Health Act 1987 uses the term mentally ill person instead of lunatic. The Mental Health Act defines mentally ill person as a person who is in need of treatment by reason of any mental disorder other than mental retardation. Insanity is an old term used loosely to denote any mental disorder or mental illness. The Indian Penal Code employs the term unsoundness of mind while referring to insanity. It is better to use term mentally ill person as defined under Mental Health Act 1987 rather than using such terms as insane or lunatic. The Mental Health Act of 1987. The Mental Health Act MHA 1987 was enacted for better treatment and care of mentally ill persons. The Act made provisions with respect to management of property and affair of mentally ill persons. The Act also provides protection of human rights of mentally ill persons. The MHA 1987 contains 10 chapters and 98 sections. First point is, Chapter 1 deals with various definitions. Here the term mentally ill person is used instead of insane or lunatic. Similarly, instead of lunatic prisoner, the term mentally ill prisoner is used, and instead of mental hospital, the term psychiatric hospital or psychiatric nursing home is used. Chapter 2 provides procedures for establishing mental health authorities at center and state levels. Chapter 3 deals with the procedure for establishment and maintenance of psychiatric hospitals or psychiatric nursing homes. Chapter 4 provides provision for admission and detention of mentally ill person in psychiatric hospital or psychiatric nursing home. Chapter 5 deals with the inspection, discharge, leave of absence and removal of mentally ill person. Chapter 6 deals with judicial inquisition regarding alleged mentally ill person, processing property, custody of his person and management of his property. Chapter 7 deals with liability to meet cost of maintenance of mentally ill person detained in psychiatric hospitals or psychiatric nursing homes. Chapter 8 deals with protection of human rights of mentally ill person. Chapter 9 deals with penal punishment, ties and procedures. Chapter 10 deals with miscellaneous particulars. Now, foreign insanity, also called as false insanity, fabricated insanity or artificial insanity. In this condition, a person fabricates the sign and symptoms of insanity. A person may find insanity to escape from punishment or with some other aim. In most of the cases, it is easy to find insanity from true insanity, but small numbers of cases may possess difficulty. Now, in this chart, difference between true and find insanity is given. In this, the particular features true insanity and find insanity is given in 3 different blocks. The feature of onset of insanity in true insanity is usually gradual, and in find insanity it is sudden or abrupt. In the feature second is predisposing cause. In true insanity it is present, and in find insanity it is absent. Third is motive. In true it is absent, and in find it is present. Next is symptom. In true insanity it is usually uniform and suggests a particular type of disorder. In find insanity the symptoms are often exaggerated and do not confine to particular disorder. Next is facial expression. In true, it is vacant, fixed or listless. In find, it is frequent, change, exaggerated, climactious. Next is observation. In true, the features continued. In insigned, features exaggerated under observation and absent when patient is not observed. Next is insomniac. Often persist for prolonged period. In true, in insigned, it cannot be withstand sleep for more period. Next is exertion. In true, it can withstand fatigue and hunger for prolonged period. In insigned, it cannot withstand fatigue and hunger for prolonged period. Next is personal hygiene. In true, do not pay attention, habits are dirty and filthy. In insigned, pretend by pay attention. Next is frequent examination by psychiatrist. In true, it does not mind examination. In find, resents because fear of detection. Now, procedure for admission of mentally ill psychiatric hospital. Procedures for admission of mentally persons in psychiatric hospitals or psychiatric nursing homes are prescribed in Chapter 4 of MHA 1987. The procedures are as follows. Admission on voluntary basis. Any major person who considers himself to be mentally ill and desires to be admitted in any psychiatric hospital or psychiatric nursing home for treatment may request the medical officer in charge of that hospital for voluntary admission as a voluntary patient. It is given in section 15 of MHA 1987. If the mentally person is minor, the parents or guardians of that person may request the medical officers in charge of the hospital for voluntary admission as a voluntary patient, which is given in section 16 of MHA 1987. Now, admission under special circumstances. If the mentally person is incapable of expressing his willingness for treatment and admission in hospital as a voluntary patient, an application on that behalf by a relative or friend of mentally ill person can be made to the medical officer in charge of that hospital. If the medical officer is satisfied that it is necessary to admit the patient as inpatient in hospital, he can admit the patient. However, no such person admitted as inpatient be kept for a period exceeding 90 days except in accordance with other provisions of the Act. Now, admission under reception order. Reception order on application. An application for a reception order made to the magistrate within the jurisdiction by the medical officer in charge of psychiatric hospital or psychiatric nursing home or by the husband, wife or any other relative of mentally ill person. If the magistrate considered that it is necessary to treat the mentally person in the interest of his health and personal safety or for the protection of others, a reception order may be passed by the magistrate for that purpose. The magistrate may also dismiss the application. Reception orders on production of mentally ill person before magistrate. Now, admission as inpatient after judicial inquisition, which means inquiry. A mentally ill prisoner is one who has become mentally ill while undergoing a sentence in jail for some offense already committed. He can be admitted to the hospital on a reception order from the magistrate after the person's illness is medically certified. Now, admission as a mentally ill prisoner. An order under Section 30 of the Prisoners Act 1900, 3 of 1900 or under Section 144 of the Air Force Act 1950, 45 of 1950 or under Section 145 of the Army Act 1950, 46 of 1950 or Section 143 or Section 144 of the Navy Act 1957, which is 62 of 1957 or under Section 330 or Section 335 of the Code of Criminal Procedure 1973, 2 of 1974, directing the reception of a mentally ill prisoner into an psychiatric hospital is sufficient authority for the admission of such person in such hospital to which such person may be lawfully transferred for detention. Now, discharge of mentally ill person. Voluntary patients should be discharged within 24 hours of the receipt of request of discharge made by the patient or if minor made by the guardian. mentally ill person received in psychiatric hospital or application made by his relatives or friends in this condition, the friends or relatives may apply to the magistrate for his discharge. Third is the medical officer in charge of psychiatric hospital can order the discharge of any patient on recommendation of two medical petitioners, one of whom should be a psychiatrist. Fourth, a person detained on reception order can be discharged if judicial inquisition finds him of sound mind. Fifth, any relative or friend of mentally ill person can make an application to the medical officer in charge of the psychiatric hospital for discharge. The medical officer in charge forwards the request application to the appropriate authority, which is the magistrate under whose order the mentally ill person was detained. Such authorities can pass an order of discharge if the relatives or friends executes a bond to take proper care of such mentally ill person. Now, criminal law and people with mental disorders. In this, the first is suicide of persons with mental disorder. Indian Penal Code does not consider suicide as a crime, but an attempt to commit suicide is considered as a crime. One of the important elements of the offence is intention to harm, which means mens rea. A person has right to live, but his right does not include the right to die. In case of absence of mental element, an attempt to commit suicide would not be considered as an offence. The attempt to commit suicide is an offence. However, the recent legislation has struck down the Indian Penal Code IPC section 3091 after a long protest by the mental health professionals. Now, theft and persons with mental disorder. When a movable property is taken away from a person without his or her consent is considered as an offence of theft. The essential element of theft is dishonest intention. Kleptomania is a mental disorder in which a person has an impulse to steal without an apparent disorder intention. If such a person does an act which would be considered as theft in normal circumstances, but his or her act would not amount to theft to punish him in true sense. The punishment for the theft committed by kleptomania should not be as prescribed in penal code but the one in need of treatment. Now, civil law and people with mental disorder. Management of property and affairs of the insane. Chapter 6 of the Mental Health Act 1987 provides for the legal proceeding to be followed in cases concerning the protection of person and property of mentally ill person or by the Advocate General of the state in which the alleged mentally ill person resides or by collector of the district on behalf of the courts of wards. The district court shall direct an acquisition where the person alleged to be mentally ill is to be unsound mind and incapable of managing himself and his property. The court may also order inquiries concerning the nature of the property belonging to the alleged mentally ill person. The person who are his relatives or such other matters are seem proper to the court. After being satisfied as to the mental illness of the person and related issues, the court can appoint a manager or a guardian to look after his property, guaranteeing him the necessary powers. The court may, it appears to be just for the mentally ill person benefit, order that any property, movable or immovable, be sold, charged, mortgaged, dealt with or otherwise disposed of as may seem most expedient for the purpose of raising money to be used for and in the interest of mentally ill person. Now, marriage and divorce. The Hindu Marriage Act 25 of 1955 provides for conditions for a Hindu marriage. Section 5(2) stated that at the time of marriage, if either party A is incapable of giving a valid consent due to unsoundness of mind, B though capable of giving consent, has been suffering from mental disorder of such a kind or to such an extent as to unfit for marriage and the procreation of children. C has been subject to recurrent attacks of insanity. Any marriage solemnized under any of the above circumstances shall be voidable and may be annulled by a decree of nullity under section 12 of the Act. Another ground for nullity under the same section is the fact that the consent for marriage was obtained by fraud as to any material fact or circumstance concerning the respondent. Divorce can be granted under Section 13 of the Act on a petition presented by either spouse on the ground that the party has been incurably of unsound mind or has been suffering continuously or intermittently from mental disorder of such kind, and to such an extent that the petitioner cannot reasonably be expected to live with the respondent person with mental disorder as a witness. Any person can serve as witness in court of law unless the court finds him incapable of understanding the question put to him because of old age or any mind or body disease or any other cause of similar type. Incompetency of a person to serve as a witness cannot be made just because he has some mental disorder, but it has to be established that because of such mental disorder, the person will not be able to understand the question put to him. Now, insanity as defense case study. In a case, the appellant was an employee in Stores branch of Northern Railways headquarters, Baroda House and New Delhi since 1958. In 1958 and 1959, he had alterations with other clerks in the office. On May 20, 1959, his superior officer observed that he was prone to lose temper in no time. In his moment of excitement, he became dangerous and used to hit his colleagues with anything that he could lay his hand on. But at the time of his great excitement, he could distinguish between right and wrong. After May 1959, he worked at his desk as a normal man. In March 1960, he again quarreled with another clerk. He was suspended and sent for medical examination. At this stage, he was suffering from mental illness. On October 12, 1960, he was examined by a psychiatrist who found that he exhibited symptoms of acute schizophrenia and showed disorders of thought, emotion, and perception of external realities. The psychiatrist said that he was harboring certain delusions. The nature of the delusions is not stated. The appellant was put on a drug named lagretide and was given convulsive electrotherapy treatment. On January 12, 1961, he was cured of his illness and was advised to join his duties. On resuming his duties, the appellant worked in the office in the normal manner. There is some evidence that on the morning of November 25, 1961 and the preceding night, the appellant complained that he was unwell and took medicine. But on the morning of November 25, he went to his office as usual. He was late in attendance and was marked absent. He applied in writing for one day casual leave, stating that he has an urgent piece of work at home. Nobody notices any symptoms of mental disorder at that time. He left the office at about 11:30 am and returned home alone. At 1:45 pm, he stabbed 3 members of his family with a knife. He concealed the knife and a search for it has proved fruitless. At 2:45 pm, the investigating officer arrived at the spot, arrested the appellant and interrogated him. He was found to be normal and gave intelligent answers. On the same date, he was produced before magistrate. His brother was then presented, but the magistrate was not informed that he was insane. On November 27, he was interrogated by the inspector. It does not appear that he was then insane. On November 30, the appellant's brother filed an application before the committing magistrate stating that the appellant was insane at the time of occurrence. The appellant was later remanded to judicial custody. On receipt of another application from his brother, he was kept under medical observation from December 16 to December 23. On December 19, the medical officer noted that the appellant was indifferent to his surroundings and personal cleanliness, preoccupied in his thought, muttering to himself, making meaningless gestures, losing track of conversations, given to delayed and repetitive answers, and unable to give detailed account of incident leading to his arrest. On December 23, he was declared to be lunatic though not violent. The psychiatrist noted that the appellant had a replace of schizophrenia. From his attitude of talk and manner, he was found to be aggressive. On September 6, 1962, it was reported that he was cured and was in position to understand the court proceeding. The commitment order was made on January 4, 1963, and the trial started in February 1963. The appellant was sane at the time of trial. According to Section 84 Indian Penal Code, nothing is an offence which is done by a person who at the time of doing it by reason of unsoundness of mind is incapable of knowing the nature of the act or that he is doing what is either wrong or contrary to law. To establish that the act done are not offences under Section 84, it must be proved clearly that at the time of commission of the act, the appellant by reason of unsoundness of mind was incapable of either knowing that the acts were either morally wrong or contrary to law. The question is whether the person was suffering from such incapacity at the time of the commission of the acts. There is an evidence of a medical character that between October 12, 1960 and January 12, 1961 he was suffering from schizophrenia. He was completely cured of the disease on January 12, 1961 when he resumed his normal duties. He had another attack of his disease in the middle of December 1961. The attack lasted till September 1962 when he was found to be normal again. But it is to be observed that the defense witness do not say that even during these two periods the appellant was incapable of discriminating between right and wrong, of knowing the physical nature of the acts done by him. After the appellant was cured of the disease on January 12, 1961, he was found to be normal. He had highly strong temperament and was easily excitable, but there is positive evidence that even at the moment of his greatest excitement he could distinguish between right and wrong. From January 12 on to November 24, 1961, he attended his office and discharged from his duties in a normal manner. On the morning of November 25, 1961, his mind was normal. He went to and from his office all along. He wrote a sensible application asking for casual leave for one day. At 1:45 p.m., he gave normal and intelligent answers to the investigating officers. Nothing abnormal in his was noticed till December 16, 1961. The thing in favor of the appellant is that though he had a motive of attacking one of the members but no clear motive for attacking the other two members, but there is clear evidence to show that he knew that his act of stabbing and killing was wrong and contrary to law. He concealed the weapon of offense. The knife could not be recovered in spite of the search. He bolted the front door of his house to prevent arrest. He then tried to run away by the back door. He then tried to disperse the crowd by throwing brickbats from the roof. His conduct immediately after the occurrence displays consciousness of his guilt. He knew the physical nature of stabbing. He knew that the stabbing would kill and maim his victims. Of a comprehensive review of the entire evidence, the two courts below concurrently found that the defense of insanity under Section 84 was not made out. He was unable to say that the verdict of the courts below is erroneous. If a person by reason of unsoundness of mind is incapable of knowing the nature of the act or that he is doing what is either wrong or contrary to law, he cannot be guilty of any criminal intent. Such a person lacks the requisite mens rea and is entitled to an acquittal. But it is not essential in the present case that the appellant was suffering from his incapacity. The general burden is on the prosecution to prove beyond reasonable doubts not only the actus reus but also mens rea. The prosecution satisfactorily discharged this burden. The appellant was not insane at the time of killing and stabbing, and he knew the consequences of his act. He was held criminally responsible for the acts. In the result, the appeal was dismissed. Now, summary. Insanity, lunacy or mental unsoundness or mental derangement or mental disorder is defined as a disease of mind or the personality in which there is derangement or impairment of mental or emotional process. The Indian Lunacy Act 1912 defined lunatic as an idiot or a person of unsound mind. The Mental Health Act 1987 uses the term mentally ill person instead of lunatic. Procedures for admission of mentally persons in psychiatric hospitals or psychiatric nursing homes are prescribed in Chapter 4 of MHA 1987. Indian penal codes does not consider suicide as a crime, but as an attempt to commit suicide is considered as a crime. Kleptomania is a mental disorder in which a person has the impulse to steal without an apparent dishonest intention. Incompetency of a person is to serve as a witness cannot be made just because he or she has some mental order.